morning. My name is Richard Shaw. I appear on behalf of the plaintiff appellant. With me at counsel table is Richard Schulman, who was the trial attorney in this case. In my brief, uncontested time, I want to make one or two points. Perhaps the point I'd like to start with has to do with policy. The legislature put a attorney fee provision into the No Fault Act for first-party cases. Presumably, the legislature understood that the attorney fee would motivate insurance carriers to promptly pay appropriate claims for insurance benefits. And attorney fees are not allowed, of course, unless the insurance carrier unreasonably denied the claim. So what will we think about a case for $8,000? If we take the position allowed by the Court of Appeals, an attorney may very well find, and I'm not proud of this, but it is also a business as well as a calling, an attorney may well determine that an $8,000 claim for insurance benefits is not worth that attorney's time. And this is, of course, true in other circumstances as well. And I don't have to do the math. If the attorney is only going to, but the legislature wanted to encourage an attorney to take that case. And this is the greatest policy reason I can think of for using the Smith versus Corey approach. I understand it is the initial step in determining the attorney fee. It is not the end step, but it's a critical and important step. And this court intended that Smith apply to no-fault cases. When I read, and by the way, thank you for having us do a supplemental brief. It helped to bring focus, at least in my mind. When I read these two cases together, to me, Smith versus Corey is a continuation of the Wood case. It's almost as if this court said, by the way, what we did a few decades ago, let me continue with the analysis. It wasn't I have a whole different approach for case evaluation when we discuss reasonable attorney's fees. Yeah, Wood has a discussion of reasonable attorney fees, but this is completely different. You cannot get that out of Smith versus Corey. Smith versus Corey does not emphasize the context in which the discussion occurs. If anything, Smith makes clear to me, and I trust to this court, that it intended to be an elaboration of the criteria that was made clear in the Wood decision. I'm willing to give up any part of the 2 minutes that I have remaining. Well, I'll keep going then.
You don't have to, unless you feel compelled.
And you know what? I don't feel compelled. Let me just say this. University rehabilitation is wrong, even though Augustine tried to narrow it to its facts. Thank you. And I'd like to have a few minutes for rebuttal.
You have quite a few minutes.
Good morning. May it please the court, Susan Brown on behalf of the appellee USAA. Taking your initial instruction to heart, the application for leave to appeal in this case should be denied for the reason that the facts of this case do not support an analysis of Mr. Schulman's entitlement to attorney fees using either the Wood calculation or the Smith calculation. In other words, whether or not Smith applies to no fault. Judge McDonald below was not presented with adequate evidence to apply even the factors of Wood, let alone the additional factors set forth in Michigan Rule of Professional Conduct 1.5 and in Smith. If the case were to be remanded, no trial court could analyze the presentation made below applying Smith. The factors of the reputation of the attorney in the community, the fees usually received by that attorney. The fact that any client had ever paid Mr. Schulman the number of dollars he was requesting per hour. Those are factors under Wood and 1.5. There's no evidence in the record about any of those three factors. None. There were 3 hearings on this. None of that evidence was ever presented. The only evidence upon which the court could have determined a reasonable hourly rate would be the use of the economics survey, the State Bar Economics Survey, which is discussed at length in Smith, both in the dissent and the lead opinion. I was trial counsel below. I attached the most recent survey to my brief to establish that Mr. Schulman had failed to establish anything regarding the reasonableness of the $350 per hour.
Let me just stop you. I don't quite understand the nature of your argument that there was no record for the court to have made any determination under Smith or anything else. What strikes me about the record is that there was absolutely no direction given to the trial judge. You supplied the survey, but you did not make the Smith argument. This record does not establish the predicate for the award of fees under Smith. Is that correct?
No, that's not correct, Your Honor. I did make the argument that there was insufficient evidence to support the reasonableness of the fee requested by Mr. Schulman. I did not make a full record that it was unreasonable because that's not my burden. It was the burden of the plaintiff to present evidence upon which the trial court could have determined that the requested rate was reasonable.
Okay, let me just ask you.
Sure.
I read the several colloquies the court had with the counsel about fees. What standard was being applied there?
It appears that Wood was ultimately being applied to the extent that it could be. Since there was no evidence before the trial...
It looked like a free form to me.
Well, you're right, Your Honor, it was a bit of a free form, but in part because none of the evidence that would have addressed either the Wood factors or the Smith factors were presented to the trial court.
Okay, let's start this way. If Smith applied, it wasn't applied here, correct?
It was not applied to the extent that Judge McDonald did not attempt to find a reasonable hourly rate.
Under that circumstance, who bears the risk of loss?
I think it depends. It could go either way, actually.
That's not a very helpful answer to me.
Well, and frankly, with the question of whether Smith should apply to no fault, I'm of two minds on that also.
Let's just...
We have to settle on one.
Well,
so do you want to pick one?
Yeah.
Well,
argue for now,
actually, on this case, no, I don't. I don't think that this is an appropriate case to determine the propriety of the Smith factors because of the dearth of evidence below. The Smith factors couldn't have been
He asked you about
applied.
saying the propriety of them. He just asked you whether it applies.
If it
said you
applied,
had
Okay,
I believe no, it does not apply based on universal rehab. The present binding precedent at the time that Judge McDonald made his ruling, and frankly to date, is universal. It's a published case. It specifically applied the reasoning of whether Smith should apply.
But it isn't binding on us.
Pardon me? No, of course not, Your Honor. But it was binding on the trial court at the time the determination was
Well, let me
made.
just try a different tack. If Smith applies, who bears the risk of loss that it wasn't?
Well, in this particular case, I think the plaintiff does, but it's not because of whether Smith applies. It's because of the plaintiff's failure to provide the facts.
Let me just kind of restate it. Smith applies for the purpose of my question.
Okay.
Now, since it wasn't, who bears the risk of loss for that fact?
Again, Your Honor, I think both parties could. It depends on what would happen on remand. Are you asking me who's going to get a bigger reward?
No.
I'm not sure
just saying that there's an error here.
Okay.
It implicates things like who bears the burden and so on and so forth. You seem unwilling to say that your client should benefit from the failure to apply Smith. If you say that it should, I was going to ask you the next question, why? But if you choose not to say, if you say, I don't know who bears the burden, who profits from the failure to apply Smith, I'll move on and let you go someplace else.
Well, my point, Your Honor, is that I don't know whether the award would be higher or lower if Smith had been applied.
But what if there's
So I don't know whether my client has a bigger risk. I'm sorry, I'm not trying to be evasive.
I'm just saying, right now we have a record. We have an award, and if the correct law wasn't applied, who never mind. Move on.
Well, my question is pretty similar. I mean, if there's an absence of evidence that makes it difficult or impossible to apply any of the enumerated Smith factors, who bears the burden of that absence of evidence?
The plaintiff would, because the plaintiff bore the burden of proof in the first place. So if the plaintiff fails to meet his or her burden, just like in a trial, if the plaintiff did not present adequate evidence at the trial, during the trial, to support his or her client's claim, and the jury came back in favor of the defense, the trial court wouldn't say to the plaintiff's attorney, you know what, you should have argued these three things, so I'm going to give you another chance. Argue these and let's see if the jury changes their mind.
The trial court gave plaintiff's counsel a very hard time in the process of counsel's attempt to justify the fee. Give me the best argument you have that the court didn't go too far and stopped counsel from presenting evidence that would have enabled us to look at the record and say, here's what the Smith factors would provide for on this record, or we need to remand it and let counsel have an opportunity to make the record he was unable to make because the trial court stopped him from doing so.
Well, if you look at the briefs, Your Honor, you can see that there was nothing presented by the plaintiff, even on reconsideration, in addition to what he had already
By the
supplied.
premise of my question, I think the trial court stopped the plaintiff from being able to do that. If you disagree, tell me.
In oral argument, I agree with you. However, it was briefed another time after that, and plaintiff still did not present any additional evidence. Now, I grant you that he could have anticipated that Judge McDonald would not have been very pleasant during the oral argument the second time around. But the fact remains that he did have an opportunity to brief it again.
To make a record.
To make a record, and failed to do so again. Now, I will agree with you that Judge McDonald's demeanor was frustrated and short. I sat through the trial. I can understand why, but that doesn't excuse the behavior. But that doesn't change the fact that the briefs submitted by the plaintiff's counsel were insufficient on both occasions. The initial motion, at which point the burden was born and nothing was presented, and the second time, once he knew that the award was going to be low, he did nothing to substantiate his claim that a $350 an hour rate would have been appropriate. There's guidance in lots of the cases about how you could do that, including in Augustine.
That's what I was going to ask. What do you think that counsel should have done here?
Well, first of all, one simple thing that he could have done without having to go to great expense would be to tell the court what he has earned in prior cases, what hourly rate his clients have agreed to. That's one of the factors under both Wood and Smith. Instead of just saying, I think $350 is good for me, I've tried a lot of cases, and this is the right amount. He could have said...
What if you're a lawyer who has never represented a client based on an hourly fee? What if you're a lawyer who takes contingent cases?
Fair enough.
Most of the time.
And that's more often than not the case in no fault. There can be situations, and there have been in reported cases, where there have been penalty attorney fees awarded to that attorney in the past, and you present the evidence of what the court had awarded you in the past. You can present the statistical evidence of, I have had this many cases, and I have earned, whether it was via contingent or not, I have earned X amount of dollars for approximately this amount of work. None of that was presented. His trial success was not presented. In other words, he said, I've tried a lot of cases. He did not say whether he tried a lot of no-fault cases. He did not say whether he'd won any of those cases. And the skill, experience, and reputation of the attorney requesting the fees is another factor under both Woods and Smith.
But
there were
counsel,
plenty.
so counsel, I guess the question I have is that I think really what this comes down to in terms of the dialogue that's taking place is how do you avoid the subjective nature? I mean, I believe that what Justice Zara was getting to was that you had a judge who seemed to have, for whatever reason, a personal issue with this attorney from what the transcripts seem to show. And I guess what this court is concerned about is, you know, in the practice of law, do you want to have some consistency that is applied in this circumstance or situation? And I guess how would we get to having that consistency, and you know, how would we allow for this to kind of move forward so we can learn from this case?
I would totally agree that we do need some consistency, and I don't disagree that a formula such as Wood or even Smith would be appropriate. But,
Well, then why do you reject the notion, as I thought you had, that Smith should apply in this context, or outside of its own context? It has been applied outside, by the way, by this court.
yes, yes, absolutely, not in no-fault cases, but yes, it has.
Well, why are no-fault cases so different that the ethical standards that apply to us as attorneys for determining fees, which were recognized in Smith, why wouldn't those be equally applicable to determining a reasonable fee in this context, a no-fault context?
They may be, Your Honor, and I'm not making the argument that Smith should never be applied to no fault. But I can address some of your questions. There are some differences in the no-fault arena than in the typical litigation field. One of which is that for under 3148, the only party that will ever be given penalty attorney fees is the plaintiff. It's never going to be the defendant.
So?
Well, that brings to the forefront the question that how are plaintiff's attorneys in no-fault cases usually paid? They are usually paid on a contingent fee basis. Using Justice Taylor's opinion in Smith, not the plurality, but Justice Taylor only, even the fact that it was a contingent fee agreement could not be considered. Likewise, the results versus the amount requested would not be considered under Justice Taylor's list in Smith. In a no-fault case, especially in a case where you could, as happened in this case, request all kinds of types and dollar amounts which were not awarded, the result versus the amount achieved is a relevant consideration, particularly in no-fault cases. Additionally, there's a little bit of a difference about getting paid as a plaintiff's attorney in no-fault, in that many attorneys are getting paid long before there's ever a lawsuit filed. They're taking a percentage of all of the voluntarily paid fees, or some of the voluntarily paid fees, replacement services, wage loss, that kind of thing. You can see by the number of ads on TV and the number of lawsuits that reach your desks that there is no dearth of attorneys willing to take on no-fault cases.
Are you saying that under Smith, the fact that there had been compensation pre-litigation should or should not be taken into consideration?
I believe that it should be. I'm not sure that it's clear under Smith whether it could be, because under Justice Taylor's list, you wouldn't consider the fixed or contingent nature of the actual fee agreement. So, and I think that's a pertinent inquiry as to what's reasonable in a no-fault case.
Is there anything in Smith that would bar the court from determining what the reasonable fee under Smith would be and then reducing it by what was paid through the course of the litigation through these interim payments?
That's an interesting question.
Go ahead.
May I continue? If Justice Taylor's formula were used, you would disregard the factor of whether it was fixed or contingent, and whether there had been payment before, and you would also disregard the factor of results achieved versus amount requested. Because it's in Smith, it's case evaluation sanctions. The determination of who made the right call or the right estimation of the value of the case has already been made. So it's a factor that's not considered in Smith itself, which is highly relevant to what is reasonable or what could be considered reasonable in the no-fault arena.
Do you feel that the judge in this case made the appropriate inquiry? I mean, basically what we're trying to do is figure out a way that we can move forward as a state in terms of allowing for people to know how to practice And I guess my question would be, would it be your position that based on the inquiry that Judge McDonald did, that that was an appropriate inquiry and that, this is the kind of inquiry that would be acceptable for the future?
I don't believe it was Justice McDonald or Judge McDonald's obligation to make an inquiry when a proper record was not established by the party bearing the burden of proof. I don't think it is the trial judge's responsibility to say, counsel, shouldn't you give me this information? Shouldn't you present this evidence? That is incumbent upon the attorney.
But then we go back to Justice Zara, who said, it sounds like it's kind of going in both directions. Then we go back to Justice Zara, who said that he really wasn't permitted to get the opportunity to present the evidence. So what I'm trying to figure out is, as we write an opinion, what do we take from this inquiry? What do we take from what Justice McDonald did? What do we take from this experience in terms of trying to develop a more uniform approach to this so that it doesn't seem to have the kind of personal circumstance that developed in this situation?
Well, I think that's the problem with this case, Justice, is that the facts aren't good for determining whether Smith or Wood should apply, let alone whether Judge McDonald could have applied it. And it's because of the lack of evidence presented below, and keep in mind that the briefs were written weeks before the oral argument. And then there was a second oral argument with a briefing opportunity in between, and at neither point did plaintiff's counsel present any of the evidence required by 4 of the 6 factors under Wood, or 6 of the 8 under.
It's a legal question. Like, what differentiates the no-fault fee-shifting statute from the FOIA and the Headley fee-shifting statutes? It's not the facts of your case that differentiate.
No, that's true. And
So-
I was answering a different question of how to direct a trial court. I think
the facts of this case make it such that we can't decide this legal
no,
question.
no, I'm not. That's not what I'm saying. What I'm saying is that Judge McDonald couldn't have done things much differently than he did because of the lack of evidence before him. And I would like, as a practicing lawyer,
No, he could have said, I conclude that Smith applies, you haven't made your burden of what a reasonable fee is, and therefore, whatever.
he could have done that. Instead, what he did was consider some of the factors and apply them. He could have said, you didn't meet your burden, I'm not going to consider any factor.
One of the issues we're trying to do is make sure that when there are fee-shifting statutes that require, or court rules that require a reasonable fee determination, that the judges and the parties are getting a consistent analysis. They might vary case to case, but they ought to have the common framework.
I agree.
What there does not seem to be here is a understanding what the common framework is.
I agree that there was an understanding until Smith, because everybody used Wood, particularly in no-fault cases. Smith came out, and then there was a split. It's not a technical split in the no-fault arena, because in Augustine it was dicta and not a basis for the ruling, whereas in Universal it was. So the law, as it stood at the time Judge McDonald made his decision, was Wood.
Okay.
And I don't disagree that there are aspects of Smith that are very helpful. I also, however, don't think that the Wood criteria, which had
You
been
like
used
the
for 20...
concurrence in Wood.
I like the concurrence.
I mean, Smith.
Actually, I like my personal opinion, I like the concurrence in Smith.
Yes.
As opposed to the dissent.
I understand.
I do agree, however, in part with the dissent in that, and this probably sounds more plaintiff-oriented than one would think from an insurance defense attorney, but that the law office, the law firm economics survey doesn't really take into consideration what plaintiff's attorneys make in the no-fault arena. And what I'm trying to get at is that it may not be, what may be a reasonable fee in many other contexts may not be in no-fault because of its unique ability to have attorneys paid long before litigation.
You're saying the judge can't make that determination under Smith?
Oh, no, a judge certainly could make that determination under Smith. I just believe that under Smith, you're starting from an artificial position by trying to come up with an hourly rate when most plaintiff's attorneys are not paid on an hourly rate. And making that a paramount decision and using the average of attorneys practicing in that field may not come up with the reasonable award in the no-fault arena, which is a little bit different from many others.
Your time is up. Thank you.
Thank you.
Do you have anything to add? How about answering my question? if Smith applies, who bears the burden of risk that it wasn't?
It's always, it's plaintiff's obligation to assume the burden of going forward.
And what was the,
And the
what was
burden of
presented-
persuasion.
What was presented to this judge?
In this case, there was a spreadsheet.
Of hours,
A spreadsheet of hours.
a declaration of an hourly fee, what, was $350?
I think that's correct, Your Honor.
And that was supported by what evidence?
It wasn't initially, but at the time that the judge then did have, and in a timely fashion, and perhaps just by chance, fortuitously, the judge certainly did have the Michigan Bar Journal survey of attorney's fees.
But again, what ties the $350 to the trial counsel's reasonable rate? I mean, the fact is there might be attorneys who can demand $350 and get it, but what evidence was there that this counsel was entitled to that as his reasonable fee?
I think counsel's position was that he was in the 75th percentile, and although
Again, the evidence.
How do we know that? What?
I take it that his position is that he had demonstrated a caliber of competency before the trial court.
The trial court, I think one of the issues with the trial court is very upset about how much the trial counsel had delayed and caused the trial to drag.
I appreciate that, Your Honor. And if the trial court had said, okay, I see that you're requesting $350, I see where this fits into the Bar Association survey, I see the hours, and here's what I'm going to do.
But again, you bear the burden as the plaintiff at this point, right?
Yes.
So I'm trying to figure out, well, what did you present that caused, if Smith were the controlling authority, what was presented that the trial judge had to consider and didn't?
He had to consider the number of hours, which he completely brushed aside. And
Not completely, because he said you prolonged the trial.
And in my brief, I said, okay, if the judge had chosen to say, I see the number of hours you're proposing, and I think you have a 10% excess number of hours, well, then we'd be talking, and we'd be talking in the context of Smith versus Corey.
Okay.
And if he said, I see that you think that you're entitled to $350, and I see that you think you're a 75 percentile attorney, but let me tell you what I think. I think you're a 25 percentile attorney. We'd still be talking Smith versus Corey. And then he might have said some other things besides.
Well, let me ask a different question.
Yes, Your Honor.
Should Smith apply and no fault?
Should Smith?
Yes.
Not only do I think Smith should apply for the reasons I tried to get in my first 2 minutes, because I think it's consistent with the policy of the legislature to encourage prompt payment of no-fault benefits rather than unreasonably delay, which of course is the criterion for these attorneys' fees. But moreover, I think Smith does apply. I think the reading of Smith unequivocally, I can't pronounce that word, but anyway, without equivocation, Smith, to any reasonable reader,
Other than the Court of Appeals.
other than the Court of Appeals, other than 2 out of 3 of the members of the Court of Appeals, suggested that this court absolutely entitled Smith as an elaboration of Woods and did not, was not carving, it was no carve out.
Now, let me ask the question. There was a difference between Justice Taylor and Justice Corrigan. Justice Corrigan, joined by Justice Markman, believed that the elimination of consideration of the contingency fee, and what was the other issue?
Results reached.
The results reached. should not be considered. They thought those were appropriate to be considered. What do you believe about the relative merit of the concurrence's position?
Wow. I think I'm a bit of an agnostic, but I guess I would not.
You could choose not to give your view on this.
No, I'll take a position. Once the trial court has revealed that it knows where it's starting and that its beginning point is the number of hours, taking into account the evidence that's available to us through the bar survey, and that it knows what the hours are and it's considering an appropriate hourly rate, I think it is reasonable to consider factors such as the existence of a contingent fee. Now, which way this cuts, I'm not entirely sure, because after all, a contingent fee attorney may end up with zero, and that might suggest that a reasonable fee, if you're going to use a putative hourly rate, should be higher. But I think on behalf of my client, it is appropriate to at least give some consideration to the nature of the contract.
Mr. Shaw.
And outcome. And outcome.
I'm sorry.
And outcome.
And outcome, but bearing in mind Judge Gleischer's dissent, there are going to be, I don't want some mechanistic approach where,
I mean, the whole thing is is to create an architecture so that a judge can exercise his or her judgment about this. And my only question is, did the Taylor opinion too quickly eliminate from the consideration two factors that, particularly in no fault, seem to be quite relevant? The fact that most of the plaintiff attorneys operate on a contingency fee and consideration of the success of the outcome. Those seem to be reasonable considerations.
I think outcome indirectly brings you back to the skill factor that's discussed in Wood. And one can draw inferences about the skill of the attorney in part by the outcome. But I think you have to be careful, as Judge Gleischer pointed out, because the outcome may be that the attorney did great, and yet it's a small value case. And as Judge Gleischer pointed out, just because it's a small value case doesn't mean that you must not spend considerable hours in discussing medical exams and MRIs and all kinds of things that I don't do.
Okay.
Can I ask a question? This may be an entirely irrelevant question, but I guess I wanted to ask it anyway. I'd like to momentarily restore the focus of our questions to the statute. Can a fee negotiated at arm's length ever be an unreasonable fee?
Context is everything, Your Honor. In some sense...
That's the premise of my question, actually.
In some sense, I'm a great believer in the market. So in some sense, the answer is I can't remember if the question had a negative in it, but a free arm's length fee arrived at is reasonable in a limited context. But I don't believe that this is what the legislature intended in the context of the statute.
So if a reasonable fee is less than the contractual or contingency fee, the attorney will be paid effectively will be paid at a level exceeding the reasonable fee and in accordance with the contractual fee. If, on the other hand, a reasonable fee is more than the contractual fee, he or she will be paid in accordance with the reasonable fee and in excess of the contract. Is that right? So it's kind of a win-win for the class of attorneys.
Well, in a tautological sense, but you may also want to consider the possibility that a contractual fee, and perhaps not in the context of personal injury, but the contractual fee may be immense.
Maybe a what?
Immense. Huge. And are we going to bind the trial court to say, well, This fee was arrived at arm's length bargain. Maybe the guy is a multimillionaire and he says millions to unleash the hounds of war and not a penny in tribute. You get my drift.
Well, you can pursue from the client whatever is in excess of a reasonable fee that's lower than the contract fee, right?
I think my answer is no, but perhaps I don't understand. Could you repeat that?
Well, if a reasonable fee is calculated at some level below the contractual or contingency fee, nothing prevents the attorney in that case from seeking to gain the differential from the client with whom he or she has entered into a contract, isn't that
They
right?
get the contract bargain whether they are awarded that amount by the court.
Well, as you put it, yes, they do get the contract fee regardless of which way the trial court goes.
So the whole harmless level would essentially be the contractual or contingency fee. You're always going to get at least that, and if you're lucky enough and a reasonable fee exceeds that level, you'll get the excess as well, right?
If I may, bear in mind whom I'm representing.
I understand.
I don't represent the attorney. It may seem like I do, but it is the goal of the client to get as high of an attorney fee in every case.
So they don't have to pay anything out of pocket.
Exactly.
I understand that.
I see that my time is up.
It
but
is.
I'll stand here as long as you wish.
Well, you don't have to anymore.
Thank goodness.
Thank you. The case is submitted and the call is concluded.
Thank you.